All right, let's dive right in. Welcome to this explainer on the Indian Constitution's right to equality. Today, we're going to decode what is truly a complex and absolutely fascinating piece of legal architecture. You see, when the framers sat down to build this new republic, they were drafting what would become the longest written constitution in the world. And they were doing it for a society that was deeply divided by caste, gender inequality, and strict colonial hierarchies. So their solution couldn't just be a simple one-line rule saying, hey, be fair. Instead, they had to engineer this multi-layered, structural approach to equality that is literally shaping millions of lives today.
But before we get into the actual legal mechanics of it all, let me ask you a fundamental question. Does true equality mean treating everyone exactly the same? I mean, it's a totally natural assumption, right? But as we're about to see, the Constitution recognizes that treating people identically, especially when they're starting from vastly unequal historical realities, can actually just create more inequality. That paradox right there, that is the beating heart of our entire discussion today. So here is our roadmap for today. We're going to cover, first, the baseline of equality. Second, fairness through special provisions. Third, equality in public jobs. Fourth, the ban on untouchability. And finally, number 5, erasing feudal titles.
Let's get right into Section 1, the baseline of equality. This is Article 14, the absolute foundation of fairness.
Article 14 is the baseline, declaring that the state shall not deny equality before the law or equal protection of the laws to any person. What's really cool here is how the framers actually borrowed from two entirely distinct global traditions to build this. First, they took the British concept of equality before law. This is what lawyers call a negative concept. Basically, it strips things away, specifically ensuring the absence of special privileges. Nobody is above the law. Full stop. Then they took that and combined it with the American concept of equal protection of laws. Now, this one is a positive concept. It demands equal treatment in similar situations, which actually permits the government to classify people reasonably. Article 14 brilliantly merges both of these ideas together.
So, because Article 14 borrows that American concept, it allows the state to group people differently. Think about how we have different income tax brackets, for example. But to prevent the government from just making up arbitrary rules, any classification has to pass two extremely strict tests. First, intelligible differentia. I know, heavy legal speak, but it just means there has to be a clear, understandable distinction. It's like sorting laundry into whites and colors. The rule is obvious. Second, you need a rational nexus. This means the distinction you made has to logically connect to the objective the law is trying to achieve. If a law doesn't check both of these boxes, no way. It's unconstitutional.
Now, for a long time, the courts basically just used those two classification tests and called it a day. But then came a dramatic turning point in Indian law. In the landmark E.P. Rayappa case, Justice P.N. Bhagavati delivered this incredibly powerful observation. He stated simply, equality is antithetic to arbitrariness. With that one single phrase, the Supreme Court declared that acting arbitrarily, or basically just acting on a whim, is the exact opposite of equality.
You can really see how Article 14 evolved over the decades. Back in 1952, with the Anwar Ali Sarkar case, the focus was purely on that reasonable classification test we just talked about. But fast forward to 1974, the E.P. Rayappa case struck directly at the concept of arbitrariness itself. And finally, in 1978, the famous Maneka Gandhi case firmly linked Article 14 with the requirement that all state action must be right, just, and fair. So it evolved into this massive sweeping shield against any unfair action by the state.
All right, moving to Section 2, fairness through special provisions. This is Article 15, adding protective layers. So while Article 14 sets that general baseline, Article 15 comes in and adds specific protective layers to deal with India's unique social realities. To really get this, we have to understand the concept of substantive equality. Remember that question I asked you at the very beginning? Substantive equality is the principle that achieving actual fairness sometimes requires treating different situations differently in order to remedy historical disadvantages. Formal equality just treats everyone identically, totally ignoring reality. But substantive equality recognizes that because certain groups face deep structural disadvantages, the Constitution actually has to allow affirmative action to level the playing field. Which brings us to the core mechanics of Article 15. It perfectly balances strict prohibitions with very necessary exceptions. First, the state completely, 100% bans unfavorable treatment based solely on religion, race, caste, sex, or place of birth.
However, to achieve that substantive equality we just talked about, it explicitly permits protective discrimination, meaning the state can create special welfare provisions for women and children and establish reservations for socially and educationally backward classes, scheduled castes, scheduled tribes, and economically weaker sections. So while discrimination is prohibited, protective discrimination is fiercely protected.
Let's take a look at Section 3, Equality in Public Jobs. Article 16, Leveling the Economic Field. Now we're going to take those protective layers and apply them directly to the economy. In a developing welfare state, government jobs provide absolutely critical economic security. Article 16 guarantees equal opportunity to compete for these jobs, but again, it provides tools to uplift those who are historically underrepresented. The defining moment for this came with the landmark Indrasani judgment. The Supreme Court had the monumental task of trying to balance merit with social justice. Ultimately, they upheld reservations for other backward classes, but they introduced what's known as the creamy layer principle. This excludes the most economically advanced individuals within those classes from getting the benefits. And crucially, they also established a general rule capping total reservations at 50%.
But fast forward to today, and this constitutional framework is facing a major modern challenge: the rapid privatization of the economy since 1991. Now, privatization obviously has clear economic benefits. It increases overall job opportunities, it drives efficiency, and it sparks serious economic growth. But there is a massive downside here. Because constitutional reservation policies under Article 16 apply primarily to the state, the shrinking of the public sector directly means the weakening of reservation policies for marginalized groups. What we're seeing is a huge rise in contractual, insecure employment in the private sector that operates entirely outside of these constitutional safety nets. It's a real tension.
Okay, Section 4, the ban on untouchability. Article 17, tearing down social hierarchies.
With Article 17, the Constitution totally shifts gears from managing employment to aggressively tearing down deeply rooted, oppressive social hierarchies. Untouchability was a profound historical evil that denied basic human dignity to millions of people. And what makes Article 17 so incredibly unique is that it is an absolute right with zero exceptions. None. You cannot justify the practice of untouchability under any circumstances whatsoever. And even more than that, while most fundamental rights just protect you from the government, Article 17 is enforceable against both the state and private individuals. It forbids untouchability in literally any form. To understand just how seriously the judiciary takes this, just look at the Supreme Court stance in the Appa Balu Ingale case. They didn't just define untouchability as a crime. They called it a direct violation of constitutional values and an assault on human dignity. You see, Article 17 isn't just about technical legal equality. It is about forcing a completely new constitutional morality and a sense of fraternity across the entire society. And finally, we arrive at Section 5, Erasing Feudal Titles. Article 18, Protecting the Republic. This is the last layer in our architectural blueprint. To protect this newly formed republic, the framers knew they had to dismantle the artificial hierarchies established that British colonial rule. Under that rule, titles like Rai Bahadur or Sir were granted just to create a loyal, privileged class. Well, Article 18 strictly bans these because they create artificial social superiority and hereditary privilege, things that are totally toxic to a democracy. But, and this is important, the state is permitted to award military and academic distinctions or national awards like the Padma Shri. As the Supreme Court clarified, these national awards recognize exceptional merit in service, but they cannot be used as permanent titles attached to a person's name. Because at the end of the day, a republic celebrates merit. It actively bans artificial aristocracy. So we've journeyed through this intricate architecture of equality, right? From baseline protections against arbitrariness, to the nuances of substantive equality, to the tearing down of ancient social evils. But I want to leave you with a provocative thought, one that really forces us to look to the future. As the private sector continues to grow and public jobs shrink, how can India continue to balance merit with the constitutional promise of social justice? The Constitution has given us the blueprint, for sure, but as our economy and our society evolve, the challenge of maintaining that architecture of fairness, well, that's now in our hands. Thank you so much for joining me for this explainer.